Thank you very much, Nicole. It is 6:19. Sounds like we still have a little microphone on. There we go. We're good. It is Free Legal Advice Day on now the second Monday of the month, but the first Monday was on the first, and the holiday and everything. We get things, moved around a little bit. Either way.
I was on vacation.
Well, there's nothing wrong with that. You got a nice tan.
I got a nice tan.
It worked out well for you. Attorney Dave Betras hanging out with us, answering your legal questions free of charge. Give us a call if you want to have him answer them live. That is the number on your screen, 330-744-8821. We already have several lined up. You ready to do this?
I'm ready. Line them up.
All right, this one came from Facebook. This person says she's overwhelmed with trying to pay for utilities and deal with credit card debt as well. She's considering bankruptcy or a debt relief program. She wants to know which would be better. What is the average cost for something like that? Pros and cons of each. She says she really does not want to give up her house.
So I would tell her to follow a woman on TikTok called The Ladylike Lawyer, who's a friend of mine. All she does is bankruptcy. And if she wants to call my office, I'll give her number. She can get some quick advice from her. She does a live sort of TikTok thing every Thursday morning where you can call in and find out that. It's not usually one or the other, and there's nothing wrong with people filing bankruptcy. It's something that's there to give people the relief from debt and get a fresh start. Actually, what's crazy is your credit score goes up after you file bankruptcy and not down. So I would tell her to look up on TikTok The Ladylike Lawyer, or to call me, and I'll give her number, and she can call her and get her the advice she needs.
Are you able to hang on to your house if you go through bankruptcy?
Well, sometimes yes, and sometimes no. It depends on what you're doing. If you have a lot of equity in your house, you're probably going to lose some of that. But I would suggest that she call me, and I'll refer her to this woman named Adrienne Hines.
All right, sounds good. We have a caller on the line. Caller, go ahead with your question for Attorney Betras.
Yes, Dave.
Yes.
Yes, I have a question about protection orders and stalking. I have a neighbor who's 33 years old. I'm 68, 67, and he won't leave me alone. I've had him in Mahoney County Court 9 times on 9 different stalking orders, and with 4 different magistrates. And this guy, he will not leave me alone. He's just has a problem now. The police were over there, and I called their city hall 4 times last week.
All right, caller, let me just try to intervene here. So you have someone you believe is did you get a temporary restraining order against him?
So get a 10th restraining order is what you're saying.
A what?
It would be number 10 on the restraining orders. Over the past 6 years, I've had 9 restraining orders against this guy.
So what's your question?
Well, you want me to get a 10th restraining order every year? I got to get them.
If he's still
understand.
Doing the things that's causing them to get a restraining order.
Exact same things, constantly, new things, and it's driving me crazy. I mean, he's an act-up kind of guy, and he lives with his mommy and daddy. He's 33 years old.
I hear what you're saying, caller, and what I want to tell you is, yes, if he's doing the things that are causing you to still have those stalking things, you are allowed to get a 10th restraining order. The whole thing about the restraining order is for him to leave you alone. And if he's not leaving you alone, then certainly go get another one.
Exactly. And it's just constantly I have to keep doing that. And it's the word is not getting through to him or his mommy and daddy. And I'm like,
well, look, if your question was, can I get a 10th one? The answer is yes, if he's still doing the same things that he was doing to bother you, okay?
Okay, I'll try to work on it. I'm getting too old to be doing these restraining orders.
Oh, you're not that much older than me. You're only as old as you feel is what I say.
Yeah, you're only a couple years younger, but I've had 4 heart conditions.
Yeah,
9
I
knee
would just go
surgery,
get
and all this stuff.
Yeah, I would just go get the 10th restraining order. That's what you need. All right.
Okay, thanks, bud.
Thank you.
All right. Well, he'll be answering questions in between segments, by the way, if you want to give that number a call or keep sending us emails, Facebook messages, and everything. We'll be back again here in about 5 minutes or so with segment number 2. We'll be back with the Farmers Trust Financial Report after the break. Back. It is 6:42. Attorney Dave Betras back for round number 2 of free legal advice day, and we already have a caller who's been waiting patiently, so we'll get right to that caller. Good morning. Go ahead with your question. Maybe. Caller, are you there? John, are you there?
No, John's not there.
Well, John is not there, but a good thing.
That was a smacking yellow tie.
Well, I appreciate that.
I love it.
I'm trying not to physically smack anybody because then that'll be a whole different legal segment.
Right.
All right, so we do have a bunch from Facebook, so while we get John back on the line, we'll go with those. This person asks, if there's no court order for custody with children, can you freely do whatever you would like if grandparents are involved or something like that?
Well, I need to know a little bit more. So if you are a single parent, paternity has not been established, and the father has to go and enforce his visitation rights. So the mother has complete control over that. If you are legally married, the grandparents, you can cut the grandparents out if you want. There's nothing a grandparent can do, only if there's a divorce. So there just wasn't enough questions in it. But I'm assuming the person that wrote this has her children, was not married, paternity was not established. She is the king of her castle right now.
All right. This one is also from Facebook. This is a mom and an uncle owned property together. The mom passed away. She had always told them that the property would just go to whoever's still living. The uncle is telling the 5 children that each of the 5 owns 1/5 of half of that property, if that all makes sense. And they're asking for the kids to get a notarized letter saying that they want to give their share now to the uncle. So would they do that through probate court, or they're asking if a notarized letter would just simply take care of whatever issue they're having?
It's so funny. People think a notary carries some kind of special magic potion with it. It really doesn't, okay? All the children have to do is deed their 1/5 share over to their uncle. So they would just simply execute a deed. All 5 children execute. They could do it on the same deed. We, Steve, Tim, Melena, and Bob, we all assign our 1/5 share over to Uncle Bob.
So do you need to go through probate for that, or can you just...
No,
all right.
you just file a deed and you take it to the recorder's office and file it, and it becomes his property.
There
you
you
don't
go.
need it.
All right, easy peasy. All right, we do have John back on the line with his question. John, go ahead.
John, you're on.
Yeah, I was on a lady's HIPAA form, and I don't know that I am now, but I was given an update on her condition by a nurse, who I am very bitter with. I don't think she's allowed.
All right, he kind of cut out
Yeah, I think we lost him, but go ahead.
So he was on someone's HIPAA form, meaning that the person who was having medical procedures done was given permission to give him information about the person's health condition. I'm inferring from his conversation that he and that woman broke up, and that he was still given that information. He was mad that he was given that information. That woman has to do something affirmatively to take him off any HIPAA forms, or that he's not to be shared with any information.
All right.
It would be unusual that a nurse would call him out of the blue, so I'm thinking maybe he did something more than just sit there and wait for his phone to ring.
All right. Well, we got one more real quick from email.
Right.
This person's dad passed away. The mom says she is the next of kin, but there are legal notarized, again, documents saying that she's entitled to his bank accounts and her name is on those accounts. So who is actually entitled to it, the wife or the daughter?
So it depends on what his will says. It doesn't say, does it say there's a will there in that question?
It does say there is no written will.
All right, so they died what's called intestate. Dying intestate means you die without a will. And a spouse has certain statutory rights. So she's entitled to, I believe it's 1/3 if there's more than one children. And so they can't cut out the mother altogether. That's what I can tell you.
Right.
She can go to court and demand her statutory rights as a surviving spouse.
There you go. He answers all the questions.
And the goodies today.
He did. They are there up, waiting to be eaten. I see.